Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources.
Welcome to the Forest Resources Committee podcast. I'm joined today by two partners at Holland and Hart, Janet Howe and Andrea Driggs, both of whom have extensive experience navigating NEPA in the context of mining, energy, and forest law. Janet Howe is a partner at Holland and Hart whose practice focuses on complex environmental litigation, regulatory compliance, and natural resource matters. Janet represents a diverse range of clients, including mining companies, renewable energy developers, irrigation districts, and municipalities, navigating high-stakes regulatory, permitting, and resource challenges. Janet's practice encompasses all phases of environmental litigation and administrative proceedings, with particular depth in matters arising under the Clean Water Act, CERCLA, NEPA, and the National Historic Preservation Act. Her experience further extends to permitting challenges, resource disputes, and water rights matters, including transactional due diligence involving water rights, acquisitions, and transfers. Andrea Driggs is a partner at Holland and Hart, specializing in helping mining and energy clients navigate cross-jurisdictional environmental and natural resource issues. Andrea's practice includes obtaining and defending key permits, conducting environmental due diligence for large transactions, and advising on NEPA, Clean Water Act, and National Historic Preservation Act reviews for exploration and mine plans. She also assists with conventional and renewable energy developers with essential permits for solar, wind, and battery storage projects. Welcome to you both.
Thanks so much for having us.
We're glad to be here.
Before we get into the specific questions we have lined up, I want to make sure that our listeners have a solid foundation. As you may know, this podcast episode is part of a Forest Law 101 series, where our aim is to provide our listeners with an overview of the legal and policy frameworks governing forests throughout the United States, whether they are privately owned or managed by state, federal, or tribal entities. As such, we hope that today's conversation will provide an overview of the interaction between NEPA and forest management, and will highlight key issues that arise when a given action is subject to NEPA review. Before we dive in, let's start at the beginning. Janet, would you mind starting us off? What is NEPA and how does it apply in the forest law context?
Happy to. So NEPA, or the National Environmental Policy Act, not Protection Act, which tends to be a rookie mistake, was enacted in 1969 and resulted from a fairly extensive bipartisan effort and was ultimately signed by President Nixon. At its core, it's a procedural statute, not a substantive one. And it's a really fundamental distinction and often misunderstood outside of the legal context. NEPA doesn't prohibit any particular outcome or dictate any particular outcome. It doesn't require agencies to reach any particular decision. It simply requires federal agencies to stop, look, and document the environmental consequences of major federal actions before they proceed. And the primary mechanism for doing that is through the environmental review process, whether that be an environmental assessment, environmental impact statement. These are just essentially the detailed reports analyzing any significant environmental effects of a proposed action and then identifying alternatives.
Thank you. Not every federal action requires a full environmental impact statement, even if the subject action does trigger initial NEPA review. Could you please elaborate on this distinction?
Sure, that's absolutely correct. So it's a tiered system, right? At the initial level are categorical exclusions, or CEs. And you're going to find this is a world full of acronyms. So CEs apply to categories of actions that agencies have already determined don't individually or cumulatively have significant environmental effects. Traditionally, these would just be routine maintenance activities, certain road building, certain, in the forest law context, salvage activities. But we're seeing a big expansion of CEs in this last year, and we'll probably get into that in further detail later in the podcast. Now, in the middle level, you have your environmental assessments, or EAs. This is a shorter analysis used when an agency isn't sure whether significant impacts will result from a federal action. If the EA concludes there's no significant impacts, they'll issue a finding of no significant impact, or FONSI, and stops there. If significant impacts are found, or if the action is of a sufficient scale, they'll move on to this full environmental impact statement. And those are the ones that are, the doorstop, right? The thousands of pages of review is the EIS.
And also, just since we're talking about the forest law context specifically, You just want to remember that here, major federal action might include things like timber sales, forest restoration and health activities, grazing permits, road or infrastructure construction, mining approvals, land exchanges, and more. And there can be disputes, of course, about whether or not something constitutes a major federal action. But just generally speaking, the Forest Service is one of the most prolific preparers of NEPA documents in the federal government. And so there's a high level, or at least in the past, there was a high level of expertise within the Forest Service. And almost all the significant management decisions on a national forest system land, they go through some level of NEPA review.
Thanks, Andrea, for tying this back to the forest law context. It's a good reminder that NEPA can apply to very different types of federal actions, which interact with the natural environment in different ways. You mentioned the hard look doctrine in your materials. Could you explain what this refers to?
Sure. The hard look doctrine is, generally speaking, it's the principle which has been developed through decades of case law where agencies have to look at the environmental consequences and not just go through the motions. So the Supreme Court has always said that this doctrine is one component of NEPA's purely procedural review, but other courts have used it to scrutinize agency decision making at a more granular level. So we'll discuss this further when we get to Seven County, but the Supreme Court's recently confirmed that this judicial NEPA review needs to be guided by the principle of substantial deference to agency decision making. And, that's really pulled back on how aggressively courts can second guess agency decisions under this doctrine.
Well, thank you both for setting the stage and providing this context. Now that our listeners have a basic understanding of the NEPA review process and its triggers, let's get into our first question. As you know, this episode is focused on NEPA's effect on transactional forest law. I imagine that when many of our listeners think of NEPA, they picture it arising in litigation. For example, a public interest organization suing to block logging operations or other projects. How does NEPA actually come up in the transactional environmental legal practice?
You're entirely correct. Most people do think of NEPA in the litigation context because it's covered so thoroughly and, it's covered in the news when it pops up in case law. Environmental groups might challenge a timber sale or a mine permit. And that does happen. NEPA is the most frequently litigated federal statute, but it also comes up in transactional practice in ways that are very consequential, albeit less visible. So, for example, we would invite both of us work to advise clients on, for example, acquisitions of mining properties, energy projects, timberlands, and we want to look at the federal nexus. So, is there a federal permit, federal land, or federal funding, or federal approval? And that allows us to know whether NEPA is in play and the status of any required NEPA review, because the status of that, whether it's being litigated, whether an EA is in process or an EIS is in process, really becomes a critical due diligence item.
Could you give us a concrete example of what this might look like?
Yeah, of course. So, for example, if a client is acquiring a mining operation that requires a plan of operations on national forest land, you would have to understand where the project is in the NEPA process. So, do you need an EIS? Likely yes. Has it been completed? Is it being challenged? Is the EIS potentially old? How are project opponents suggesting that it might need supplementation? The answers to all those questions will directly affect your project timelines. They can affect financing and also risk allocation in the transaction.
And the same is true for energy project development or other development, conventional energy, renewable energy, any kind of federal permits that you would need to do a right of way across federal land, Section 404 permits under the Clean Water Act, or approvals under the National Historic Preservation Act often trigger NEPA review. So we advise clients on how to structure their projects and permit applications to manage that process efficiently. The key point for transactional lawyers is that NEPA risk is a real business risk. If an EA or EIS will be required, it's critical to start that process early. Scoping, stakeholder engagement, collecting data, and performing analysis. These are all tasks that project developers can help complete early in the process to get a head start on it. Under the Forest Service's new NEPA regulations, the sponsor can actually take a bigger role in the process and complete a lot of the underlying documents that are then approved by the Forest Service. So a completed unchallenged EIS is obviously an asset. data and analysis that goes towards that EIS is obviously an asset. An incomplete or legally vulnerable NEPA record is a liability to a project being completed.
That's a really helpful framing. So, what are the most common federal permits or approvals that trigger NEPA review in forest-related deals? And in this context, how do you advise clients who may want to avoid triggering such review?
So I would say in the forestry and mining context, the most common triggers we see are like Andrea was saying, plans of operations on national forest system lands for mines, which are required for mining activities that go beyond casual use, as well as special use permits for rights of way or even land exchanges, maybe a little less common, but still something we see out there. And important, just going on a plan of operations, you could have a plan of operations on private land that have some kind of federal nexus, right? Like that gets into the permitting that I was talking about earlier, or special use permits. For forest resources, timber sales, road construction, restoration projects on federal lands, these are also major categories that directly impact forest resources themselves. Increasingly, we're also seeing NEPA triggered by renewable energy projects, solar, wind, transmission lines. A lot of these types of projects will need rights of way across federal land and can't be avoided, especially in areas like the West, like Arizona, where we just have substantial swaths of federal land all across our state.
Thank you. So, how do you advise clients who are concerned about NEPA becoming an obstacle to a project?
So, I mean, the biggest thing is to think carefully about whether their project actually has a federal nexus or requires that federal nexus that's going to trigger the NEPA review. Does the project actually going to require certain federal permits or approvals? Whether the project can fit into an existing category exclusion. This question is getting so much more important now as we see like the transition of WOTUS or, the expansion of categorical exclusions. We really just try to see what is necessary for their project and whether NEPA review is actually even going to be necessary here.
And Janet, I agree with you. Like certain types of mining and exploration activities can qualify for CE if they fall below the acreage or disturbance threshold. So this has always been the case that routine forest management activities have established CEs. So if the client can structure their project to fit within one of those CEs, that's a legitimate and very efficient path for the NEPA review. Another thing that we talk to agencies about, I talk with clients about, is engaging early with the agencies. So the whole scoping process, which is the initial phase of NEPA review, where you identify the issues to be analyzed, that's a critical opportunity where you can shape the scope of the review itself. So clients who engage proactively at the scoping level, they tend to have better outcomes than those who show up later in the process.
That's a really practical point. It seems, and it is my hope, that in effect, a project developer revising its development plans in order to qualify for a categorical exclusion may result in a project that is less environmentally damaging than originally proposed. In this way, early engagement seems like it would pay dividends for all parties involved.
Yeah, I agree with that. And I think that clients, people sometimes are concerned about drawing attention to their project or triggering litigation, but the agencies need to do the review regardless. And I think the real question is whether you've had input into how the issues are framed at the outset, whether you have the baseline data that you'll need for the NEPA review. And so I think early engagement really is critically important.
Last year, the Forest Resources Committee released a podcast episode in anticipation of Seven County Infrastructure Coalition versus Eagle County, the most significant NEPA case before the Supreme Court in more than 2 decades. The court handed down its decision on May 29th, 2025. Andrea, can you walk us through the ruling?
So Seven County involved the Surface Transportations Board. That was the lead agency. They were approving an 88-mile railroad line in Utah's Uinta Basin. And that's an area where there's a lot of oil and gas resources. So the railroad, but it's also very isolated. The railroad was intended to connect the basin, rich in crude oil, like I mentioned, to the National Freight Rail Network. And that would facilitate the transportation of oil to refineries along the Gulf Coast. The DC Circuit had actually vacated the EIS before because the DC Circuit said that it didn't sufficiently analyze the environmental effects of this upstream oil drilling and the downstream oil refining. And those are activities that were enabled by the railroad, but they were entirely separate projects and they were not within the board's regulatory authority. The Supreme Court reversed. This was a unanimous decision on the judgment, and the majority opinion was written by Justice Kavanaugh and joined by the Chief Justice and Thomas Alito and Barrett. Sotomayor then wrote a concurrence where she was joined by Kagan and Jackson, and then Gorsuch was recused in this case.
Thank you. This is clearly a significant decision in the NEPA context. Could you please summarize the key holdings of this case?
Sure, and I agree with you. I think it's the most significant decision since Public Citizen, the most significant decision in over 2 decades. So there's 2 main pillars to the court's decision. First of all, the court reinforced very empathetically that NEPA is a purely procedural statute. The agencies are required to prepare the EIS. It doesn't mandate any particular outcome. The agency's only obligation is to prepare an adequate report addressing the environmental effects of the project at hand. The court also confirmed the decision in Public Citizen and held that agencies are not required to analyze the environmental effects of separate projects, so projects that are spatially or temporally distinct from the project under review. And that's really holds true for projects over which the agency has no regulatory authority, which was also a holding in Public Citizen. So nothing new there, but the court felt like there had been some deviation from its previous instruction, and it wanted to emphasize that the courts needed to be deferential to the agencies, particularly in these situations where the agency has no regulatory authority over purported effects downstream or upstream.
I would just add to that, 7 County is this huge decision, right? We all love talking about it. We could just talk this entire podcast about it. But practically, it's very in line with the Supreme Court's prior NEPA case law about how arbitrary and capricious review should be undertaken, the scope of authority, like Andrew was saying, with Public Citizen. But the court really just used this opportunity to kind of deliver this very strong message about deference in that context and deference to agencies' review. I mean, the opinion uses the word deference repeatedly. And if you start reviewing the decisions coming down post 7 County, you will see the words repeatedly used over and over again in lower courts decisions, which is exactly what 7 County is designed for, right? It's designed to have lower courts properly apply Supreme Court precedent and to have this kind of deference to agency review, not micromanaging agency choices and just looking at whether they're falling into this broad zone of reasonableness. And I really do think we're already seeing the effects of that, and it's going to reshape how lower courts are approaching NEPA for years to come.
Thank you both for this helpful explanation. Janet, you touched on this a bit in your previous response. Do you think 7 County was correctly decided?
I do. I really do. Whether or not you need to go with the majority or the concurring opinion, that's definitely up for debate. But I think it's consistent with years of Supreme Court case law. It's consistent with the understanding that NEPA is a procedural statute, and lower courts have at times used it as a substantive tool to block or indefinitely delay projects. I mean, we're seeing this all over the place, just projects that are taking decades to reach completion and finalization of an EIS. The requirement that agencies analyze the effect of separate projects over which they have no regulatory authority was always difficult to justify textually and has been prohibited by Supreme Court case law as early as 2004. So it's just a reiteration of that. There's a really great post 7 County decision. It's a concurring decision out of the DC Circuit that I always recommend people take a look at, just because Judge Henderson just does this really scathing concurrence with the 7 County majority, and she just walks through how NEPA review in this country has become this multi-year process, thousands of pages of EIS, millions spent on environmental review. And it, really does it's a nice cathartic experience to go through and think about, why this kind of correction decision is going to be so important to project development.
And I agree with all of that. I think that 7 County really does ensure that courts aren't second guessing reasonable agency judgments about how deep to go on issues that are at the margin of the agency's authority. When you think about the area of expertise. It's really the agency that has the scientific and technical expertise here. And it's a very reasonable position for the court to say, yes, the courts can decide questions of law. But when it comes to matters where the agency has the expertise and that expertise is specifically um, provided for, then the court should be deferring to that agency's expertise.
That's an interesting point, and certainly touches on one of the primary criticisms of NEPA, namely that its procedural review process may be susceptible to misuse by those seeking to unduly delay projects, and particularly those who have motivations that are wholly unrelated to the environmental impacts of the proposed project. Moving on, let's talk about NEPA's real-world effects. It is important to recognize that NEPA can lead to positive environmental outcomes. In the Pacific Northwest, for example, NEPA review of federal timber sales has repeatedly led to identification of old growth stands and has resulted in redesigned harvest plans. On the other hand, as mentioned, NEPA opens the door for litigation that could significantly delay projects, including forest thinning efforts that are critical for wildfire prevention. In your experience, has the NEPA review process been to the benefit or detriment of the projects subject to review?
I think this is one of those situations where it's a both and answer, not an either or. So NEPA review, I think, does really produce benefits. It forces agencies and project proponents to think carefully about environmental impacts before committing to a course of action. There are many projects that can be redesigned, for example, to lessen environmental impacts. And so there can be positive benefits for project design.
Yeah, I agree with that. And I would just say, a lot of project developers that we work with, they really welcome the opportunity to complete and address the environmental impacts and engage in the public participation component. And they see it as something that has real value, not only for, making the best version of their project, but also just to get them really important social capital and buy-in for their communities, because that's, you wanting to be a good citizen in the community. It gives NEPA gives these affected communities that voice, tribes and other stakeholders, a say in the process. And agencies and project developers typically learn things throughout the process and they wouldn't have known otherwise. So there's definitely a real benefit to having the process in place.
Yeah, I think that's a really important point to consider. On the other hand, there are real costs. I imagine, particularly from the perspective of a project developer.
Absolutely. And NEPA litigation has become a significant source of expense and delay. So while there's a benefit to completing the process, there is also a real benefit and need for that process to be, efficient and predictable.
And also, if you consider the forest management context specifically, if you have delays in forest thinning or fuel reduction projects, that can be a serious concern because especially in this changing world with the changing climate, wildfires don't wait for NEPA litigation to resolve. And so, if you have a project that's designed to reduce fuel loads and it ends up tied up in court, the forest could burn in the interim, and that's a cost that doesn't get factored into the analysis. So all the good intentions in the world may actually block really worthwhile projects. And that spans the spectrum, renewables, forest resources, what have you.
I think that's a really important perspective when thinking about NEPA's real world consequences.
And also, I think that's one of the reasons there's growing support on both sides of the aisles that NEPA reform is necessary. It's not, I think, to eliminate the environmental review, but it's also to make it work better and faster. There's a frequently cited statistic that the US mine permitting takes longer than every country in the world except for Zambia. And so I think that there are definitely ways to expedite the process while still paying attention to the environmental consequences, still allowing community input and some of those other positive goals.
Thanks, Andrea. That leads nicely into our next question. As environmental lawyers who also represent project developers, how do you square these two aspects of NEPA? On one hand, NEPA plays an important role in providing a public process to identify and evaluate environmental impacts. On the other hand, many criticize it as unduly prohibitive and subject to abuse. Are there aspects that are beneficial and others that are harmful?
Yeah, we're kind of already circling around this, so maybe this just can kind of bring it home. There's certainly room for NEPA to fulfill the function that Congress intended, which is important, right? The informational function. It's supposed to ensure that decision makers and the public have good information about environmental consequences before decisions were made. This was the recognized need when this law was passed with overwhelming bipartisan support, and it's a genuinely valuable function in itself. And it can lead to real project design changes and stakeholder engagement.
But there's also a dark side to NEPA, and that has evolved through decades of litigation where project opponents have used NEPA as a lever to delay or block projects. And that's really regardless of their environmental merits. And we've seen that in a number of prominent cases where, if you delay a project, a land exchange, say, for 2 decades, the project proponents may eventually give up. I think that function is problematic. And I think that some of the language we see in Seven County and some of these other cases, like the one Janet mentioned, the Appalachian Voices, that's in direct response to this misuse of the law.
So, are there aspects of the NEPA process that you find particularly valuable or problematic?
The aspects that I find most valuable, I think the public participation requirements and the general analysis. Thinking about environmental consequences and hearing from affected communities. We talk about this social license to operate, this concept, and I think it is a very important concept um, to ensure that projects are acceptable to the communities in which they operate. And so I think that that can produce better decisions. We can have potentially changes made to project design in response to the analysis or public participation. And I think that those are helpful and valuable functions as long as they're not taken to the extreme where it's just perpetual litigation that's used to block projects.
Yeah, and I would say the aspects that are most problematic, I mean, there's a few, right? That one is this kind of open-ended scope of review. This was something that Seven County attempted to address head on, right? To encourage lower courts to constrain and not start thinking about the impact of a project so far downstream that it's completely outside of the agency's regulatory authority and, maybe based on several other contingencies. There's also just the aspect of double guessing or checking or doubting agencies' decisions, questioning scientific decisions instead of the appropriate deference. So that's also something we see a lot in NEPA review and NEPA analysis, and hopefully what we're going to see Seven County do this kind of course correction that it's supposed to do. It's a real irony, just to go to Andrew's point earlier about some of the in the effort to promote NEPA, we'll end up blocking some of the really important projects we need to fight climate change, things like clean energy projects, wind farms, solar installations. All of those are really important in addressing environmental issues. And that's even called out in Seven County as well.
Yeah, I agree with all of that. The court in Southern County noted that project opponents have used NEPA to fight clean energy projects, everything from wind farms to hydroelectric dams, solar farms, geothermal wells. And that's a real problem when you are working on the energy transition and on some of these issues. And I think you can say the same thing for mines that have been blocked by the NEPA process that would supply critical minerals needed for the clean energy transition. I mean, ultimately, this isn't an issue of merit. This is an issue of litigating by project opponents until projects die just because of the carrying costs of some of these projects and the financing concerns.
I imagine that you've both been exposed to a wide range of views on NEPA throughout your careers. What insights have you gained into how NEPA is viewed differently within industry, among public policy professionals, and in the environmental advocacy community?
Well, I think as you would expect, the differences are pretty significant. But though I would say perhaps not always in the ways that you'd expect. I would say like while due to the way that the NEPA process has been undertaken in this country and since its inception, industry clients do tend to view NEPA primarily as a cost and timeline risk. But I think they also understand that the process is legally required and that there are benefits from the engagement. And a lot of times they're not trying to cut corners or skimp on any review of their project, just trying to make, a reasonable, predictable review, focusing on efficiency and actually getting to the end completion of the review to start the project. The analysis should be effective and should be quick. It's often frustrated by what they see as this kind of scope creep, right? Where at the beginning to assess some effects leads to the effects assessment of additional effects, and then you get a district court decision that says now you have to assess even more downstream effects. So I would say it's a little bit more nuanced and complicated than one would think. It's not just NEPA bad, no NEPA. Yeah, that's at least from the industry side.
Yeah, and also, you can look at the public policy world as well, and the views there are also varied. I think there's a recognition, growing recognition, even among people who care deeply about environmental protection, that NEPA delays have real costs. And that includes clean energy projects that are essential for climate change. So the irony of NEPA being used to block wind farms and solar projects is something that courts have also raised.
From my experience, it seems that in the environmental advocacy community, it seems like NEPA is often viewed as one of the few meaningful tools available to challenge federal decisions on these major projects that communities maybe are not entirely in support of or believe are wrong. These challenges are, though, as we've been discussing for the last half an hour, so they're going beyond what NEPA was intended and beyond, the review that's supposed to happen. And so I think when we think about balancing all of these different viewpoints, we really just need this system that preserves these genuine benefits of NEPA, but reduces the way that it can be misused to obstruct projects.
Thank you both. It's interesting to consider that the views on NEPA, even if differing, are not quite as black and white as one might expect. Could you speak about some of the changes to the NEPA that we've seen in the last year and a half associated with the rescission of the CEQ regulations, as well as any other notable changes that may be worth mentioning to our listeners?
Yeah, absolutely. 2025 was a really big year for NEPA, and 2026 is also shaping up to be the same. And it's not just Seven County, but obviously Seven County is going to have a huge impact. As we just mentioned, when President Trump took office, he signed the executive order rescinding the CEQ NEPA regulations, and that was in line with some judicial decisions that were doing the same. So, I mean, this was probably something that might have been might have been expected for a while. And so now we have each of these NEPA administering agencies promulgating their own regulations. What we're seeing from that is that, the DOI is promulgating a group of regulations, USDA is promulgating a group of regulations, and they're all having some distinct differences and some similarities, tracking closely to the 2020 CEQ regulations under the first Trump administration and aligning with Seven County and aligning with the Fiscal Responsibility Act and amendments to NEPA. We're seeing a trend in them, and that's to streamline NEPA review, limit the scope of review, and try to find ways to make it a little bit more efficient. Although each agency they are taking some distinct approaches.
And that's one of my concerns is if you have these disparate approaches by different agencies who often have to work together on a project, how do you kind of square that circle when you're trying to expedite NEPA review generally? And I think there's definitely some work that needs to be done there. We're also seeing other expedited NEPA procedures that are authorized by executive action. So, for example, the Energy Emergency Declaration that calls for a completion of an EIS in 28 days and an EA in 14 days for certain critical mineral or energy projects. I mean, those timelines are incredibly fast for an EIS. And in order to complete that in the permitted time, I would think there'd have to be a lot of work beforehand or project preparation by a project proponent. So, I think it remains to be seen how effective those will be.
And just specifically for forest resources, just to touch that since we are in the forest resources podcast, many of the measures outside of, the USDA new regulations that will affect the Forest Service review, there's also just a really bigger push to expand categorical exclusions. I mean, we've seen the use of categorical exclusions rising in NEPA and forest resource NEPA case law in the last few years, but now just expanding the actual exclusions themselves, adopting way more exclusions from other agencies and then promulgating their own. All of these are in line with several executive orders that were issued this last year about trying to encourage and promote more domestic logging and lumber production.
There's clearly lots of interesting activity going on in this space. Do you think that these measures have been effective in achieving their intended results?
I think that litigation risk is always a concern with NEPA reviews. And so, are we seeing projects receive permits on a quicker timeline? I think the answer is yes. I think that's definitely intended. But I think that we need to see how that plays out in the courts and how these very expedited timelines will be seen in terms of litigation risk.
Yeah, I think that's probably one of the most important questions that we all need to ask right now. We're watching the effect of Seven County in the lower courts and seeing, changes in how courts are reviewing NEPA documents. But some of these other changes that these new NEPA regulations are calling for are very untested. 28-day EISs, not publishing a 28 EIS, not doing cumulative effects. These are all untested. And right now, our court system has years worth of NEPA case law interpreting what is required. Some of that is tied directly to the statutory language. Some of that is based on CEQ regulations, but it's really unclear what courts are going to do with that case law as they have to deal with these new agency regulations that are changing what some might see as, structural components of the NEPA process. And we combine that with this post-Chevron world we're in now, right? Because we can't ignore that context, which is so important. Since the Loper Bright decision, even though, yes, Seven County, as Andrea was talking earlier, did kind of give some context for how post Loper Bright courts would consider agency's decision in NEPA, comparing a legal conclusion versus a factual assessment. It's still going to be interesting how that's going to come into play with these new NEPA regulations and whether courts are going to uphold them or find them inconsistent with the statute itself.
And ultimately, the developers want certainty and efficiency in this process. So I think that many would be less interested in a 28-day review if there's a real risk of the decision being vacated or additional delays. So I think that they would prefer a typical process, limited the timelines that are established by the FRA, which is 2 years from the completion of an EIS, for example. And that would give you a complete and defensible record. So, um, I think the expedited timelines are attractive hypothetically, but many companies are very concerned about litigation risk and the feasibility of putting an EIS, which is a very complicated document that looks at a range of issues together in a 28-day period.
Yeah, I agree with all that. At the end of the day, I think knowing the process is key. And, obviously wanting an efficient and effective process is important. And that's one thing I think Seven County really tried to respond to, the fact that project developers were being pulled into endless delays instead of just what they could expect from a predictable, effective process. It seems like some of these potential emergency procedures or other changes could end up running the similar risks on the other end of the spectrum because there's still a lot of uncertainty tied to them.
This brings us to our final question. NEPA is commonly criticized as costly and inefficient, but I do think that some sort of method to improve the environmental impacts of federal projects and keep the public aware of potential impacts is necessary. Given your experience, what do you think the best solution would be?
Well, I don't think there's a single solution. There's a number of reforms that could improve the system and without sacrificing NEPA's purpose. And those might be more effective than some measures that we've been talking about. So, for example, if you look at scoping, I think the Seven County decision helps by it limits the obligation to analyze separate projects. But agencies still need good tools to define the scope of review at the outset and stick to that, as opposed to this scope creep where agencies are being asked to analyze environmental effects that are far beyond their purview.
Yep, I agree with that. And I would say too, as we're going to see the impact and importance of Seven County, we really need to think about a similar type of decision or limitation on the other major procedural laws that accompany NEPA. This would include things like NHPA or National Historic Preservation Act review or Endangered Species Act review. These reviews are often conducted in conjunction with NEPA, and they can end up also being their own source of delay and expense, just like NEPA. So if we are going to put all these efforts into streamlining and guarding against the misuse of NEPA, we also really need to look at the misuse of these other statutes as well.
And I also agree with Janet's point on categorical exclusions. I think when you have categorical exclusions for well understood project types, we have decades of experience, we have a robust body of data. You look at something like forest thinning, for example, certain types of that, a categorical exclusion process should be readily available. I think we're moving in the right direction there because the agencies have been working to expand on the actions that can be covered by these CATXs.
And I would say finally, I think we really need the litigation standard to be calibrated appropriately here. Seven County moves the needle in the right direction by emphasizing deference, but courts still need to apply that standard consistently. There should be the goal should be to ensure that NEPA litigation is in check on and used for genuinely deficient environmental review, not a tool for relitigating policy disagreements over, the decision to allow a major federal action to occur in the first place.
And I think you want to cabin NEPA to its intended purpose, where you want to ensure that agencies make informed decisions with meaningful public input. So, as the court said in Seven County, NEPA is a procedural cross check. It's not meant to be a substantive roadblock. And so you want to inform agency decision making. You don't want to paralyze it. We've seen with many of these projects. And if we can get back to that core purpose, I think the law then works well for everyone.
Well, thank you both so much on elaborating on a topic that has nuance and clearly differing perspectives. Do either of you have any final thoughts?
Yeah, this is just a genuinely dynamic area of the law right now. Seven County, I know I say it a lot, but I think it warrants saying it a lot. It really is changing how NEPA review is happening. And we're going to be watching closely as lower courts dive into considering these emergency procedures, these new NEPA regulations, and seeing what kind of comes out of this at the end. It's an exciting time to be practicing this space. We're seeing projects move forward that have been installed for years. And it is a really exciting time to actually see the system start working more effectively. It's fun to watch, and there's just a lot to pay attention to.
Janet and Andrea, thank you so much for joining us today. This has been a really interesting conversation, and I know that our listeners will find it incredibly valuable.
Thank you so much for having us.
It was our pleasure.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at americanbar.org/environ. Please check where you found us for future episodes. Thank you for listening.